LiSTNR production.
A fatal encounter in far north Queensland. A sex worker lured to a hotel and brutally murdered. The victim's injuries were horrific. Who was responsible? And how does a court determine who committed the murder when two suspects blame each other? I'm Dan Mullins. This is Crime Insider's Judgment, a deep dive on a judge's final verdict of a crime and what transpired to incite that judgment. In July 1995, sex worker Grace Heathcote was lured to a Cairns motel under the guise of friendship. But what unfolded was a brutal murder. Her body was discovered in a motel room with injuries so severe they shocked experienced forensic pathologists. Injuries included a rupture of the heart and a tearing of her liver. Her autopsy found her liver had been pulped from being jumped on or stamped on. She also had multiple rib fractures, a broken nose, and extensive facial and chest lacerations. We spoke with one of the investigating officers, Craig Duran, on Crime Insider's Detectives. He cast his mind back to 1995.
It was a dispute over territory and money, and they had lured the victim to a hotel room. They pretended it was going to be a service between the two women that were there. They drugged her champagne, and when she fell asleep, they started just jumping up and down on her for, I don't know what period of time, but it would have been quite a while to actually have done the damage. And none of them were really large women either. They were all just quite average build. It always stuck with me because, number one, the scene that I saw was just horrific, and I just assumed we just had some psycho John on the run who would have done this with incredible anger issues, and it ended up being these two women. And to this day, I still can't get my head around as to how they could have done that sort of damage to her.
Within 2 days, two women, Kerri Catherine Lowrie and Kerri-Leah Michelle Ross, were identified as persons of interest. Both were ultimately charged with murder. Their first trial resulted in convictions, but years later their appeals were heard anew by the Queensland Court of Appeal. Each woman sought to shift blame to the other. Both denied delivering the fatal injuries. Both claimed they were present only for a drugging and a robbery, and the plan had gone wrong. The appeal court judgment, delivered by Justice David Thomas, reads: At the first trial, neither applicant gave evidence. This time, both appellants gave evidence, each blaming the other for the killing. The evidence reveals a degree of involvement on the part of each appellant in arguments to lure Ms. Heathcote to a motel room and to drug her so that money could be obtained from her. The evidence also suggests that some violence occurred between the three women in the room, but each appellant denied having inflicted violence of the kind which is proved to have killed Ms. Heathcote. Each claimed to have been absent from the room at the time when it is to be inferred that the other woman must have inflicted these fatal injuries on Ms. Heathcote. Each claimed to have seen nothing that had caused Ms. Heathcote's death. There is no other possible cause of the death of Miss Heathcote than the acts of one or both of the appellants. The Crown's theory was that Ross and Lowrie devised a plan to drug and rob Grace Heathcote. The court heard Lowrie arranged the encounter by booking a room at the Cairns Motor Inn and inviting Heathcote under the guise of a social meeting. The court heard Heathcote had been offered a massage. Ross brought Valium, which was dissolved into a bottle of champagne. After drinking the tainted champagne, Heathcote became drowsy, but what followed spiralled into horrifying violence. The Crown alleged both women participated in an assault that resulted in Heathcote's death. Lowrie denied striking the fatal blows. She admitted helping to plan the robbery, luring Heathcote, administering the drugged drink, and even cleaning up the scene afterward. But she claimed Ross was solely responsible for the fatal injuries. Ross, for her part, claimed the opposite, that she arrived to find Heathcote already gravely injured and Lowrie panicking. She denied any involvement in the actual attack. The case against both relied heavily on their own shifting statements to police, forensic evidence such as bloodstains in the motel room, and conflicting testimony from the accused. One of the most critical issues on appeal, especially for Lowrie, was whether the jury had been properly instructed under Section 7, subsection 1 of the Criminal Code. This section outlines how someone who aids, enables, or assists in a crime may be held criminally responsible. Lowrie's counsel argued that the trial judge failed to adequately explain the law under Section 7, especially the distinctions between aiding, enabling, or directly committing the offence. Lowrie's counsel also argued the original trial judge failed to warn the jury about the dangers of relying on Ross's testimony, given that she was a co-accused, offering evidence that deflected blame from herself. Section 7 of the Queensland Criminal Code is central to understanding how criminal responsibility can be attributed not only to the person who physically commits an offence, but also to those who aid or enable it. The section relevant to this case reads, "When an offence is committed, each of the following persons is deemed to have taken part in committing the offence and may be charged with actually committing it. A. Every person who actually does the act or makes the omission which constitutes the offence. B. Every person who does or omits to do any act for the purpose of enabling or aiding another person to commit the offence. And C. Every person who aids another person in committing the offence." So let's look at how it is applied. Example A applies to the actual perpetrator, the person who physically carries out the criminal act, that is, the person who strikes the fatal blow. Examples B and C apply to aiders and enablers. A person may be criminally responsible even if they didn't strike the fatal blow, provided they took steps to enable or aid the crime to happen, and knew that the principal offender intended to commit a serious crime, such as murder or grievous bodily harm. In Lowrie and Ross's case, the prosecution did not need to prove who inflicted the fatal injuries. Instead, under Section 7, both women could be found guilty of murder if they were present at the scene, participating in a joint plan, such as to drug and rob Heathcote, aware at any point that the violence escalated to life-threatening levels, and continued to assist or enable the assault once aware of that risk. The trial judge explained this to the jury, noting that someone who joins in a plan to assault and rob, and who becomes aware that deadly violence is being used, may still be guilty of murder if they continue to assist. Lowrie's defence team raised significant concerns. It argued that the judge failed to adequately explain the differences between the sections B and C, or to identify what specific acts Lowrie did to qualify as an aider or enabler. The court rejected the suggestion, finding that the broad principle that aiding someone with knowledge of murderous intent makes one guilty had been adequately conveyed. Ultimately, the Court of Appeal found that while the language used in the judge's instructions was not word perfect, it was legally sufficient. The directions had outlined that a person must know that the other intends to cause grievous bodily harm or kill. Continued assistance once aware of lethal violence could render the aider guilty of murder, and the jury must be satisfied beyond reasonable doubt that the accused contributed significantly to Heathcote's death. The court concluded that these instructions were both lawful and adequate. Ross's legal team raised two specific grounds of appeal. The first ground of appeal was what was referred to as the Detective Hogan issue. Ross claimed the trial judge erred by refusing to allow her counsel to call a Queensland police officer, a Detective Hogan, to testify about a key moment in the investigation. In March 1996, Lowrie had given a statement in a police interview implicating Ross in the murder. Ross argued that this statement was made only because Lowrie was offered an indemnity, a form of legal immunity, in exchange for testifying against her. Ross wanted Detective Hogan to confirm that such an offer was discussed, suggesting it could show Lowrie was biased and had a motive to lie. But the trial judge ruled this was a collateral issue, essentially one going only to credibility, not admissible unless specific legal exceptions applied. On appeal, the court upheld that ruling. It noted that Lowrie's allegations against Ross predated the indemnity discussions by several months. Her March 1996 was a repetition, not a fabrication. And even if there had been negotiations for an indemnity, Lowrie had already made the same claims earlier. There was no fresh inconsistency or fabrication that would have justified calling Detective Hogan. The issue was dismissed as legally irrelevant. Ross's side also argued the judge erred by not allowing cross-examination of a Crown witness, Kerri-Leah Nowlan, using the contents of a sealed envelope from a previous sentencing hearing. Nowlan had testified that Ross confessed to her while they were both incarcerated at the Brisbane Women's Correctional Centre. Ross's team sought to discredit her by suggesting Nowlan was a police informer, implying she had a motive to lie in order to gain favour with authorities. The sealed envelope, submitted at a 1995 sentencing, likely contained material about Nowlan's cooperation with police. Ross's team hoped to access it to attack her credibility. The Court of Appeal rejected the argument. It found the contents of the sealed envelope were not admissible as they would only go to Nowlan's credit. The application amounted to an attempt to use hearsay and violate the rules protecting informers unless it was necessary to prove innocence. And Nowlan had already been cross-examined thoroughly about her past and denied any wider informing activity. The court found this application entirely misconceived and upheld the trial judge's decision to deny it. Coming up, what occurred on that fateful night in far north Queensland in 1995? I'll read from Justice David Thomas's judgment in the appeal court being heard in the Supreme Court in Cairns. Ross's account, both to the police and at trial, may fairly be described as totally exculpatory of herself and as conceding virtually nothing. She denied ill will towards Heathcote. She denied being party to any plans to drug or steal from her. She did drive Lowrie to the motel, knowing that Lowrie had an appointment with Heathcote, but she knew nothing of a mixture being put in a champagne bottle. She did notice that there was an opened bottle of champagne in the car while they travelled to the motel, as she saw it spilling out in the bottom of the car, but she did not question Lowrie about it. After dropping Lowrie at the motel, she later telephoned her for the time when she should pick her up and was told that it would not be any more than an hour. She had phoned her again at 9:25 p.m. and had been told that she'd be ready in 10 or 15 minutes. When she drove to the motel, she saw Lowrie already coming across the road. Lowrie was hysterical, saying, "She's just stabbed me," and had something wrapped around her hand. Lowrie told her that an argument had started and that someone had hit someone with the chair and someone had hit someone else with the bottle. Ross asked how Heathcote was, and Lowrie had said that she was fine. They then went back to Lowrie's place. On the following day, Lowrie, who was being, quote, pretty pushy, unquote, persuaded her to come to Mount Isa with her, and she went. She noticed that Lowrie was in possession of Heathcote's bag, ring, and watch. On the way to Mount Isa, Lowrie told her that she might as well tell the rest of the things that happened, and proceeded to tell Ross about a mobile battery being shoved in Heathcote's throat, the stomping on her, and her statements that, "I hit her hard, I hit her very hard, slamming her face into the walls, and that she should have torched the place, and she was glad she was dead." She described Lowrie as being very relaxed about it and laughing about the way to commit the perfect murder. Ross said that she was absolutely horrified. There is, however, other evidence of the women being seen together after this time in an apparently friendly relationship. Ross explained her continuing association with Lowrie by claiming that she was frightened of Lowrie and found it difficult to escape from her. Both Heathcote and Ross were sex workers and were known to one another. Lowrie was interested in becoming a sex worker and was acquainted with Ross but not with Heathcote. Although Ross denied any ill will towards Heathcote, there was considerable evidence supporting the fact that she harboured a grudge against Heathcote, arising at least in part from Heathcote's failure to pay a debt to Ross. It was arranged between the two appellants that Lowrie would make an appointment with Heathcote and lure the victim to a motel as part of a plan to obtain payment of the money owing. The plan was to supply the victim with champagne to drink, which had been laced with a drug that would put her to sleep or make her drowsy. While she was in that condition, her keys would be taken, and Ross would use them to enter the victim's home and steal her money or belongings to repay the debt. Lowrie booked the motel room and made a telephone call to the victim, resulting in Heathcote agreeing to give her a massage at the motel room. Heathcote arrived at the motel by about 8 p.m. During that evening, motel guests heard some loud thumping noises coming from one of the rooms. Medical evidence suggested the time of death to be about 9:30 p.m. At about 11 p.m, a friend of Heathcote's attempted, unsuccessfully, to call her on her mobile phone. He then attended at Heathcote's residence and found that her security door was unlocked. It may be inferred that the attack and the burglary of Heathcote's premises had been completed before this time. Her body was found in the motel later that night. 2 days later, the appellants travelled together to Mount Isa. On the 8th of July, however, the appellant Ross contacted police and made allegations incriminating Lowrie as solely responsible for Heathcote's death. Her account was that she had been approached by Lowrie, who had made it known that she wished to obtain work in the sex industry, that Lowrie had told Ross that she had made contact with Heathcote and had arranged to meet with her, that she had dropped Lowrie off at this meeting, and upon returning to collect her was informed by Lowrie that Heathcote had stabbed her in the hand and foot, and that she, Lowrie, had retaliated, and that Lowrie had also said that when she had left the motel room, she thought Heathcote was pretending to be unconscious and that she was breathing. The police immediately interviewed Lowrie, who initially denied any involvement at all in the killing. While initially admitting that she had made the motel room booking, she claimed she left the room before Heathcote arrived. However, the following morning, on the 9th of July, she implicated Ross. She described Ross's apparent hostility towards Heathcote, of the plan to drug Heathcote and obtain money back from her, to attempt to drug Heathcote at the motel, her leaving the room and seeing Ross go into the room, her going back after Ross left the room, her finding blood on the walls and floor, and her finding Heathcote with her face kicked in and a black box in her mouth. She alleged that Ross had gloves on and that they had both attempted to clean up. It is unnecessary to present greater detail at this point, but it is relevant to note that from as early as the 8th of July 1995, Lowrie's version unequivocally implicates Ross as the person responsible for the death. Lowrie gave evidence that in June 1995, she had been in financial difficulties. Ross had assisted her in starting work as a sex worker. She became aware of ill feeling between Ross and Heathcote. Ross asked her to drug the deceased so that she, Ross, could take Heathcote's keys, go to her house, take money thought to be owed to Ross, and then return the keys to Heathcote. Ross and Lowrie would then travel to Mount Isa to work as sex workers. They had together purchased rubber gloves so that they would not leave fingerprints in Heathcote's premises. In execution of this plan, Lowrie said Ross was the organiser, but she, Lowrie, was the one doing all the dirty deeds. Consequently, Lowrie made arrangements for Heathcote to attend upon her at the Cairns Motor Inn. Lowrie took with her a bottle of champagne and a Valium-based syrup which Ross had prepared. Upon Heathcote's arrival, Lowrie gave her a glass of champagne laced with this syrup. After a time, she became drowsy. Lowrie received a telephone call from Ross to tell her that Heathcote was sleepy. A little later, Ross came into the room. To Heathcote's statement, "What the fuck are you doing here?" Ross replied, "We've come to get the money you owe me." Apparently realising Lowrie's involvement, Heathcote picked up the champagne bottle and hit Lowrie on the head with it. Lowrie hit her back. A struggle ensued in which Heathcote jabbed Lowrie's hand with the broken champagne bottle. Ross and Heathcote then proceeded to have a bit of a fight, mainly scuffling and grabbing, both speaking to each other fairly colourfully. Lowrie then took a chair and hit the pair of them with it. She swung it around and hit them and got out of that room. She said she didn't do it to hurt either one of them. She then went and sat in the car. After remaining there for some time, she returned to the room where she saw Heathcote on the floor with something in her mouth like a box or a TV control. Ross was sitting astride her, hitting her in the head. Lowrie yelled, "What have you done?" Ross got up, but continued to swear at Heathcote, yelling, "Where's the fucking money?" Lowrie removed the object from Heathcote's mouth and noticed that Heathcote was making gasping noises. Ross told her to leave her alone, that she deserved everything she got. Lowrie told Ross that she had spilt the Valium on the bed and was then told to grab the sheets and throw them into the shower. A clean-up attempt followed, during which Ross wore gloves, but Lowrie did not. At that stage, Lowrie thought that Ross and Heathcote had had a fight, and that the worst-case scenario would be that Grace would have a sore throat from the thing being in her mouth. She and Ross then drove to Heathcote's flat, using Heathcote's keys to gain entry. They removed various items including money, lingerie, and perfume. Ross asked Lowrie to gather up all Heathcote's mobile phones because she wanted to ruin her business and wanted to destroy her. They then returned to Heathcote's house, where Ross showered and changed clothes. They separated later that night. The appellants had considerable contact with one another on the following day, and then drove to Mount Isa together, departing on the second evening after the incident. Some days later, when Ross contacted the police, Lowrie was interviewed and various statements to the police followed. The case against Lowrie. After her initial denial to the police of involvement, Lowrie was interviewed by police on no fewer than 5 occasions between the 8th of July 1995 and the 6th of February 1996, and she provided a written statement on the 8th of March 1996. These accounts and her evidence in court admit her involvement in the plan to drug and steal and a certain degree of personal violence on her part towards Heathcote, but not of the kind that could account for the fatal injuries. There was some independent evidence of Lowrie's presence in the motel room in the form of stains of her type of blood on the carpet or floor, which might have come from the cuts to her hand and foot, which, when medically examined, she was later found to have. There is also the evidence of Ross, which, if entirely accepted, would make Lowrie solely responsible for the murder. In any event, Ross's evidence tends to confirm Lowrie's presence at the scene and her arrangements with Heathcote, although there is an abundance of other evidence of these matters, including that of Lowrie herself. Before we get to the appeal, we need to look at forensic evidence. It played a crucial role in establishing the presence and likely involvement of Kerri Lowrie at the crime scene, as well as in illuminating the nature of the attack on Grace Heathcote. Firstly, bloodstains. One of the key pieces of forensic evidence was the discovery of bloodstains in the Cairns Motor Inn motel room that were found to match Lowrie's blood type. The stains were found on the carpet or floor and were consistent with cuts later found on Lowrie's hand and foot. These injuries were medically examined and confirmed. There was what is called injury correlation. These blood traces, when combined with the timing of Lowrie's injuries, supported the Crown's case that she had been present in the motel room at the time of Heathcote's fatal assault or immediately afterward. Although Lowrie admitted to some degree of physical involvement in the robbery plan, she denied causing fatal injuries. The forensic findings, however, helped place her at the crime scene during critical moments. Then there was what's called the scene disturbance. There was further forensic evidence suggesting an attempt had been made to clean up the room after the attack, supporting the prosecution's theory that efforts were made to conceal the use of a spiked drink and possibly blood or other signs of violence. This bolstered the Crown's narrative that the perpetrators, Ross and Lowrie, engaged in post-offence behaviour to destroy or remove evidence. A unique feature of the case was that both women testified against each other. Each accused the other of being responsible for the murder. The appeal heard, the initial trial judge declined to give a formal direction, warning the jury to be cautious in relying on either's evidence. This was another point of contention in the appeal court. Lowrie's counsel argued that a caution, often called an accomplice warning, should have been given regarding Ross's testimony, but the appeal court rejected this notion. It found that in circumstances where both accused gave evidence, or both were clearly trying to shift blame to the other, each had a strong motive to lie, and the jury did not need to be reminded of what was already glaringly obvious. The appeal judges found giving such a direction might even have confused or unfairly prejudiced one party over the other. The absence of a caution, it found, was not an error. In the end, the Queensland Court of Appeal dismissed both appeals. Neither Ross nor Lowrie had identified legal error sufficient to overturn their convictions. The court noted that the trial judge's directions on liability under the Criminal Code were sufficient. There were no errors in refusing to admit evidence relating to indemnity negotiations or informer status, no miscarriage of justice had occurred, and the evidence against both women was strong, including their own admissions and the forensic trail left behind. The appeal judge, Justice Muir, agreed with the initial trial's judge, Justice Thomas's detailed reasons, and the appeal was dismissed in its entirety. At its core, the appeal was about whether the justice system did enough to guide the jury through challenging arguments, especially when there are clearly motives of self-interest and a desperation to escape serious charges which attract serious jail time. Ross and Lowrie both tried to save themselves. Both were present. Both knew what the plan was. And by the court's reasoning, both bore responsibility, even if neither of them raised a hand in the fatal moment. Both Lowrie and Ross were sentenced to lengthy prison terms, their considerable appeal process finally coming to a close more than 5 years after the death of Grace Heathcote. Thanks for listening to Crime Insider's Judgements. We love hearing your feedback, so please rate and review this episode. If you have a case you want us to cover, let us know via Instagram at LiSTNR Crime or TikTok at LiSTNR Crime Team. I'll be back again next Thursday with another case. I'm Dan Mullins, with sound design by Niall Fernandez. This series was recorded and produced on Gadigal land.